Hello and good afternoon. My name is Ann Colleton. I'm the Policy and Outreach Coordinator at Georgia Justice Project. And on behalf of GJP and Women on the Rise and the Justice Reform Partnership, I want to welcome you to this Talk Justice Tuesday that focuses on probation, how to seek early termination of your Georgia felony probation sentence, and how to navigate a felony probation sentence in Georgia. GJP and Women on the Rise are two of the 90 member organizations and individuals that make up the Justice Reform Partnership, a coalition that brings together grassroots organizations, advocates, directly impacted individuals, and policy experts, all committed to driving criminal legal policy change and supporting and amplifying the voices of justice-impacted individuals. This Talk Justice Tuesday event is actually part of a series that will take place every month in 2025 on the second Tuesday of each month, led by various member organizations on a different topic. So I don't think the June event details are posted on the website yet, but we'll post a link in the chat where you can click on and learn more about the other events that the JRP will be hosting. So our agenda for today is that I'm going to just give a brief overview of Georgia Justice Project and what we do, and then Robin Hassan, the Executive Director of Women on the Rise, is going to speak about their work and her experience on probation. And then my colleagues, Elizabeth Rainwater, Rachel Holmes, and Dominique Harris will talk about early termination of probation and some best practices. We will not actually have a specific time to answer question and answer on the agenda. But if, as we're presenting, you're confused or need clarification on what was presented, please put your question in the Q&A box, not in the chat box, in the Q&A box, and we will do our best to answer it either in writing or to clarify it verbally. Today, we will not be able to answer any specific questions related to individual probation cases because we can't give legal advice without seeing all of your case disposition information. But you will hear a lot of information today, and I think that by the end, you'll have great guidance and it'll answer a lot of your questions. And if you still have more, we will share contact information at the end where you can reach out with specific questions. So about the Georgia Justice Project, we are a nonprofit legal organization based in Atlanta. We were founded over 35 years ago, and our mission is to reduce the number of Georgians under correctional control and to reduce barriers to reentry. We do that in three ways. We provide direct legal representation to people at various stages of the criminal legal system. On the front end with defense, in the middle with early termination of probation that you hear about today, and then on the back end with expungement. We also work to change laws and to drive policy change. So, for example, we help pass an expungement law, and then we help people with expungement. We pass a probation law, which you'll hear about today, and then we help people with early termination of probation. And we also do a lot of community education and outreach, such as this event today. So our Pathways Over Probation campaign. So first of all, shout out to Robin and the Women on the Rise team for coming up with this name. Several months back, I called Robin and said we wanted to start an awareness campaign about early termination of probation options. And I said, do you have any suggestions on what we could call it? Because we'd been brainstorming a long time and hadn't really come up with anything. And then this is the name that Robin suggested, and we all loved it immediately. And so thank you, Robin, for helping us name this campaign. So why do we need a campaign? Georgia has more people on probation than any other state in the country. Not because our crime rate is highest and not because we don't use prisons as much as probation. In fact, our crime rate is 26th in the nation. Our incarceration rate is 4th in the nation, and we have the #1 highest rate of probation in the country. So it's about how our state responds to that behavior, not about behavior itself. Our probation sentences are 3 times longer than the national average, and many states cap their probation sentences at a few years, but in Georgia, 40% of our probation sentences are longer than 10 years. So in 2021, GJP helped pass a law, Senate Bill 105, that allows people to terminate their probation early. And you hear a lot about this. Is well, you're going to hear about later. And so far, 20,000 people have been able to end their felony probation sentences early, which is great, right? 20,000 people off paper, but there are still 175,000 people on felony probation in Georgia, and we want to do more to bring awareness to this option. So you will hear a lot about that today. And now I'm going to pass the floor to Robin, the Executive Director of Women on the Rise. And not only does Robin and her team have a knack for very clever and inspiring campaign names, but we work with Robin on a lot of things, whether it's voting rights education, the survivor justice bill that was signed into law yesterday, and now partnering on early termination options. So thank you, Robin, for all that you do. And Robin's going to share about her work and her own experience with probation.
Thank you so much, Anne. Thank you. I am Robin Hassan Simpson, the Executive Director with Women on the Rise, Georgia. And we are an organization of women that have been impacted by the criminal justice system. We work doing two things. We work on reentry to make sure that people that are coming home don't go through the experiences that we came home with, not being prepared because the information we got in prison was not correct. And also we help change laws and policies that affect us to not go into the system in the first place, and also help us when we coming home to be successful and removing all these barriers. I wanted to share with you my experience of getting off probation and going through the probation process with GJP. And I will give a lot of recognition to Anne and to Rachel, because they're the ones that pushed me into doing this. And I'll tell you why it was a push. Because when we think about probation, nobody wants to be on it. Nobody wants to have the feeling of being watched and being controlled, of what you can do, where you can go, and the permissions you have to get. The last minute phone calls of having to go and get drug tested, even if you've never been on drugs in your life, just having to go through those things that they are requiring of you. I will say that one thing that I've talked to a lot of people about is the fear of going through and reopening up those wounds again, because you do have to talk about the offense you were charged with, and you have to address it and think about it again, and talk about the different things that conditions they were giving you, things that, that have caused you harm, and now you have to reopen those wounds. So that is something that I was in fear of doing. But I did it I got past it, and I was able to talk about it and get through it so I can get to a bigger goal. And another thing is a fear of rejection. I think a lot of us that have been incarcerated and we have filed that paperwork, or we have done a lot of things to try to overturn our sentences, and we always got that rejection of, you don't fit, or no, you're not going to get this. So I had that fear as well, like to get my hopes up about my probation sentence, which I had 15 years of probation after doing 10 years inside of prison. To get that no was also a big thing for me as well. So I was really concerned about that. But once again, you have to look at the bigger picture of what you could possibly obtain if you do go through this process. I will say that the process, they made it very easy. They made it very simple and very supportive. So when you're talking about, your case, or you're talking about any of those things, the support that you get is not this cold, I'm just taking notes, and it was really personable. So they made the process much easier to go through. Another thing I do want to address is the fact of a lot of us thinking, well, I'm on non-report, so why do I need to go through this? What I learned in my community, we call non-report we call it a number. That's not non-report. You still have to call a number. You still have to answer those questions over the phone every month. I know a couple of times that I've gotten busy and I've forgotten to call it. Then they're calling my parents. And of course, your family is freaking out because they're thinking you're about to get in trouble. So I learned that is not really freedom. So once I went through the process and was able to get off of probation because I fit the criteria, then I realized that was true freedom, because I didn't have to call that number anymore. I didn't have to get that special permission because I'm going outside of Metro Atlanta. I now can do last minute trips that my family wanted to do because I didn't have to wait on that permission. I can now go and spend my money the way I want to. I didn't have to go and tell them how I was spending my money. So it really depends on the different requirements that the state was asking of you. And then also the biggest thing I will say that I'm very, very excited about, this year will be the first year that I can actually vote. So being able to get off probation early, which is 10 years earlier, because I could have done it at 3, But as I said, I let my fear overtake me, and I did it at 5 years. But now I got 10 years of my life back, where I can do what I want to do. But also that gives me the opportunity to be able to vote. So now I've registered to vote. I now can take a part of something that I talk about to the rest of Georgia, the importance of why we should get out and vote, why we should have our voices being heard. Now, instead of me just talking about it, I can be a part of it. And that's a feeling that I can't even describe. It's not just, I don't have to report to anyone because I am a grown woman. Why do I have to report where I'm going? But now I have the freedom to speak up and say who gets to represent me, and the right person to speak up for the things that I need. So that is exactly why you fit the criteria of getting off probation, facing those fears. We are here to help. If you need someone to help you walk through the process, even though Ann and Rachel were wonderful, Elizabeth was wonderful as well. She helped me a lot. So if you need that support and you need that help, you can always reach out to us. Our information, I'm sure they will share that. If you do need someone to just talk to about it or help you with GJP about it, Women on the Rise is here to help you. So I thank you all for listening, and I will pass it on to Rachel Holmes with GJP.
Thanks, Robin. And again, thank you so much always for all of your work and everything. Like Robin said, my name is Rachel Holmes. I'm a managing attorney here at GJP on our defense side. And I'm here just to kind of get us started on a little bit of talking about early termination of probation, the process in Georgia, who qualifies, and how you can make sure that you are eligible when the time comes to be able to get off of probation. So like Ann mentioned, this law went into effect in 2021. And we have done a lot of work to kind of continue to get the word out. But again, we know there's more people out there that are eligible. So what does the new law do? It allows every individual who's on felony probation, who were sentenced in Georgia, to be eligible for early termination of their probation. So what this law does is creates a very clear criteria, process, and court standard for people to be able to know if they're eligible and to know how to work to get off of probation at that time. And so the most important part is who can become eligible for early termination under the early termination law, and that is everyone. And what that means is there is no exceptions, there's no carve-outs. All cases can be considered for early termination. And of course, we will talk much more in detail about how to get through that and the different criteria that will that you must have. But the real thing is after 3 years of probation, every individual on felony probation can become eligible for early termination as long as you meet the 3 criteria. And so a real question though is, when does my 3 years start? And I think that one thing we want to make very clear is that is 3 years of that you've been serving on felony probation. So this does not include any time that you've served on parole. So a lot of times in Georgia, they use a lot of Georgia uses a lot of split sentences is what it's called. So that means you serve some time in custody in prison and then some time on probation. And you have to complete your parole sentence and do 3 years of probation before that. So that means that if you were released early from your prison sentence and had to serve some time on parole, you must complete that time on parole successfully before you're able to move forward. Another thing that you need to think about when you start the 3 years of probation, though, is when did you get any credit for time served? So if you did serve a prison sentence, then you'll be looking at like what's called your max release date, and that would be the time that you would be serving on parole until that time started. If you did not have any time in custody and just got a straight probation sentence, then your probation would start at the day of that you were sentenced. It would start the 3 years then. We are going to show you just a quick example for this. So let's say John was given a 10-year sentence in January 1st of 2020. The sentence was 2 years to serve in custody, followed by 8 years on probation. John was released early from prison on January 1st of 2021. That means he served 1 year in custody in prison, and now he has another year that he's on parole. His probation will not begin until he has served 2 years of his custodial sentence, regardless of if it's jail, prison, or parole, which means that when sentenced on January 1st of 2020, he had 2 years to serve. So that means his probation would not start until January 1st of 2022. That means that his early termination date is January 1st of 2025. So that means that that is the date that he becomes eligible for early termination. It's really important to calculate this when you first get on probation, so you'll be able to talk to your probation officer and know from the very beginning when you're eligible for early termination. To talk about all the criteria for early termination, I'm going to pass it over to Elizabeth Rainwater, our staff attorney who leads our early termination work at GJP.
Thanks, Rachel. Good afternoon, everyone. My name is Elizabeth Rainwater, and like Rachel said, I am a defense attorney. I started out at Georgia Justice Project focusing through an Equal Justice Works Fellowship on probation work, and I still get to do that now as a staff attorney. So I want to move us on. Rachel just covered that for an individual to be eligible for early termination of probation, they need to have served 3 years of their probation sentence. So now I want to talk about what are the criteria that a person needs to have met in order for probation, their probation officer to be willing to recommend them for early termination. So assuming I've served 3 years of my felony probation sentence, I need to have no new arrests since I was sentenced for the case I'm on probation for. My probation cannot have been revoked in the past 24 months, and I need to have paid all restitution. So I'm going to walk us through each of these criteria and get a little in the weeds here to try to make sure we're all clear on what these mean. So no new arrests. So no new arrests since I was sentenced for the case I'm on probation for. Minor traffic offenses, an arrest for a minor traffic offense will not exclude a person from early termination of probation. So a good example of this is driving on a suspended license. If I was arrested for driving on a suspended license, that's not going to exclude me from early termination eligibility. I will say we get this question a lot. Does an arrest that didn't result in a conviction, so maybe it was dismissed, does that disqualify me? That technically will disqualify you, but it's good to talk to your probation officer about that because I certainly know there are probation officers who have recommended folks, even though they have been arrested, when that arrest has ultimately did not result in a conviction. So it's good to talk to your probation officer in advance about this, and we'll talk more about what those conversations can look like. But I want to move on to no revocations in the past 24 months. So when I say in the past 24 months, what I mean is in the 24 months prior to becoming eligible for early termination. So I cannot have any revocations for my probation sentence. But what is revocation? A revocation means that I violated my probation, and as a result, I was sentenced to serve time in custody in jail or prison. So a violation is, and I always want to tie this together to make it clear, a violation of my probation that results in a revocation means that I had to serve time in custody. So if I violated my probation, maybe I wasn't reporting to my probation officer, and I was called into court for that, and I was required to, I was given a sanction, so maybe more community service. That's not a revocation. A revocation is only if, as a result of violating my probation, I serve time in custody. So modifications of my probation, sanctions like I just gave you an example of with added community service, status hearings where I may have to appear before court, that is not a revocation. So no new arrests, no revocations in the past 24 months. But let's talk about, I talked about how a violation triggers a revocation. But let's talk a little more about violations. So a person's probation can be violated if they violate what's called a general condition or a special condition of their probation, or if they've been arrested for a new misdemeanor or felony. So a general condition of probation, these are conditions that most people on felony probation have. They apply to a lot of folks, so it could be sometimes vague, such as avoiding injurious and vicious habits. It's a little foggy. Really what that means is not doing behavior that could harm you or someone else, but that's not super clear. There are some that are pretty clear, like not changing your address without letting probation know, maintaining employment, paying fines and fees. Another somewhat vague one is not associating with people of disreputable character. These are conditions that we tend to see in most people's sentences who are on felony probation. Special conditions, however, are conditions that are specific to your case. So this could include, for example, if I am on felony probation for an aggravated assault and the named victim in my case is Bob, my special condition might say Elizabeth will have no contact with Bob. It could be abiding by a curfew. It could be getting treatment or counseling for substance use or mental health. Special conditions, like I said, are specific to your case. So what's a special condition for my case is not necessarily going to be the same for someone else. Additionally, some special conditions are ongoing, meaning while I'm on probation, this is always going to be a condition. So for example, no contact with Bob. That is something that's going to stay a condition as long as I'm on felony probation. Some of them can be completed. So for example, might say Elizabeth has to complete inpatient treatment. And once I complete that, that's checked, I'm done. So that's the difference between general conditions and special conditions. So violating a general condition or a special condition can cause my probation to be revoked. But let's talk about kind of the penalties here and how that works. So if I violate a general condition of my probation, or maybe I'm arrested for a new misdemeanor, I could have my probation revoked up to 2 years. That does not mean my probation has to be revoked the full 2 years. That just means the maximum the judge can revoke me, meaning put me in custody as a result of my violation, is up to 2 years. However, and this is part of why we really want folks to understand the difference between their general conditions and special conditions. If I violate a special condition of my felony probation sentence, or if I'm arrested for a new felony offense, the penalty is much more severe. So I could be revoked up to the remainder of the time I have left on my probation sentence. So let's say I had a 5-year probation sentence and I had served 2 years of it, and then maybe I violate a special condition of my sentence. That means the judge could revoke me for the 3 years I have left on that. So it's really important for folks to understand the difference between their general conditions and special conditions. For a lot of reasons. One of them is because the penalties are different. Another thing I want to briefly touch on is if I'm serving a first offender or conditional discharge sentence, if I violate my probation, the penalty is much more significant. The judge could take away my first offender status, and or they could revoke my probation. They could also resentence me up to the maximum time permitted for each offense I'm on probation for. So for example, if I'm on a first offender sentence for a felony theft by shoplifting, the maximum I could have gotten is 10 years. The judge gives me 5 years of probation. If I violate my probation, the judge could take away my first offender status, revoke my first offender status, and resentence me up to 10 years. So again, it's really important to understand the difference between our general conditions, special conditions, as well as understanding the implications it could have if I'm serving a first offender or conditional discharge sentence. So we've talked about the 2 of the criteria. I want to hit on the last one, paying all restitution. So restitution is court-ordered payment to a victim. Not all of us on felony probation have restitution as a part of our sentence. Restitution is not the same as fines and fees. Restitution, like I said, is money that's being paid to the victim in my case. So for example, and I'll talk more in detail about the difference between fines and fees and restitution in a minute, but an example of how you can see whether you have restitution or not is by looking at your disposition. This is your sentencing document from the case you're on probation for, and that should tell you whether or not you were ordered to pay restitution, and if you were, how much. You can also ask your probation officer if you're required to pay restitution if it seems like it's unclear on the disposition. Just make sure when you talk to your probation officer, if you're asking if you owe restitution, don't just say, do I owe money or how much do I have to pay? Because your probation officer might give you an amount that includes fines and fees and probation supervision fees. You want to specifically say, am I required to pay restitution? And if so, how much? But the clearest way to find that out is by looking on your disposition, which you can get by contacting the clerk of the court in the county you were sentenced in. So if restitution is not fines and fees, what are fines and fees? So fines, fees, sometimes you'll see statutory surcharges, These are unique from restitution. These are costs, they're not going to a named victim in the case. They could include court costs, they could include fees associated with the charge. So a lot of drug offenses carry certain fines that come with it. Public defender fee is another one. The Georgia Crime Victims Compensation Program, some people might see that on their disposition, and probation, monthly probation supervision fees are also there too. So on the right of the screen, I have a portion of a disposition, so a sentencing document that, and I bracketed off where it kind of talks about the amount of money a person has to pay. So not all dispositions look the same. They're not all formatted the same way. So don't think it's going to look exactly like this on disposition if you're looking at one for you or someone else. But here we can see there's court costs of $100. There's an appointed attorney's fee. So it's really important to look at your disposition because it's going to give you the breakdown of fines and fees, and if any restitution was ordered, how much. In some situations, folks might have had a restitution hearing after they were sentenced. And so there might be a document that is a restitution order, and that hearing was specifically about how much restitution do I have to pay? And there might be a restitution order, but you would know if you had a restitution hearing. So in most cases, you can just look on the disposition and find it there. So just a practice tip here while we're talking about fines and fees. What if I can't afford to pay my fines and fees? So again, I'm talking about fines and fees, not restitution. If I'm on felony probation with fines and fees, I'm not able to make the payment, I can request what's called a hardship exemption application from my probation officer. This application waives my fines and fees, and it's really important to get an application, a hardship exemption application, and not just either not pay and not say anything, or sometimes I know folks have said, oh, my probation officer says they're not going to revoke my probation or try to violate me for not paying, but those fines and fees are still accruing, they're still adding up, and they will have to be paid. So the hardship exemption application waives those. It's really important to get one if you are unable to pay your fines and fees, and you can talk to your probation officer about how to get that. Another option is that fines and fees can be converted into community service hours. But again, restitution can't be converted into community service hours, and it cannot be waived. So if someone is having a hard time making their monthly payments, the first thing I tell them to do is get the hardship exemption application so that their fines and fees can be waived. Next, I always tell people try to make, even if it's minimum, even if it's just a small amount of monthly payments towards the restitution, because making consistent payments is really helpful and really important to keep you in good standing with probation. But can my probation be revoked for not paying my fines and fees? So your probation can only be revoked for failing to pay if the court can prove that your failure to pay was willful. So meaning you could have paid and you chose not to. So in general, they cannot just revoke you for not paying fines and fees, and certainly not if you are financially unable to. They have to prove that you could have made those payments and you chose not to. One thing I do want to mention is that we've talked to folks sometimes where they were told that they have to make payments, their fines and fees or restitution the next time they report. And so the probation officer might say, hey, next time you report, you better make sure that you make a payment. And so what happens is sometimes people will not report because they're afraid their probation's going to be violated because they're unable to report. Like I just said, not paying because you're unable to is not going to result in a revocation of your probation. However, failing to report to your probation officer can result in a revocation. So make sure you're having conversations with your probation officer about your ability to pay, talking about the hardship exemption, and even if you cannot pay, do not just stop reporting, do not just stop showing up, because that will result in a revocation of your probation. So we've talked about the criteria. 3 years on probation, you meet the criteria of no new arrests, no revocations in the past 24 months, and you've paid all restitution if you owed any. Now I want to talk about the process here for early termination. And when I'm talking about the process, specifically what I'm talking about is the process for your probation officer to start the early termination process for you. So if people are listening in and they're like, I don't meet the criteria, that's not me, hang with me because we're going to talk about another way folks can pursue early termination even if they don't meet the criteria. But I'm talking about if we're on felony probation and we're wanting our probation officer to start the process for us, which is the most efficient way to do it. So if I've served 3 years and I meet the criteria, generally my probation officer will submit a petition to terminate my probation. And they will send that petition to the prosecutor and to the court where I was sentenced originally. In some circumstances, depending on my sentence, probation has to submit what's called a progress report to the court, and they have the option to submit a petition to terminate my probation. So I'm going to break that down for us a little bit on this next slide. So if I know we've exhausted the criteria at this point. If I've been on probation 3 years and I meet the criteria, I am eligible for early termination of my probation. But what does my probation officer have to do at this point? So that depends on the sentence I received. It doesn't depend on the offense I was sentenced for, necessarily depends on the sentence. So there are two situations in which probation has to submit a petition to terminate my probation to the court. So the first one is if I am on probation for my first felony offense. So this could include first offender, conditional discharge, or if it's not first offender, conditional discharge, maybe it's just my first felony offense. And I received either straight probation, just probation, or I received not more than a year to serve in custody, followed by probation. If that's me, then my probation officer has to submit a petition to terminate my probation at my 3-year mark. If that's not me, maybe I am sentenced for a qualified offense. I'm on probation for a qualified offense. A qualified offense, they're listed out in Georgia Code 42-821. I won't list them all there, but some of them include burglary in the second degree, certain drug offenses, certain theft offenses, forgery. So there's a list of qualified offenses. So if I'm on probation for those just qualified offenses, regardless of how much time I had to serve in custody, regardless of how much probation time I had, at my 3-year mark, if I meet the criteria, my probation officer has to submit a petition to terminate my probation. So those are the two categories where my probation officer has to submit a petition to terminate. And again, they're submitting that to the court and to the prosecutor. If that's not me, then I fall under what we call the all other offenses. So we call those green boxes. We say if someone falls under those categories, one of those two categories, they're on what's called the mandatory pathway. Probation has to submit a petition. If not, they're under what we call the discretionary pathway. Probation still has an obligation to fulfill here. After 3 years of probation, they will submit what's called a progress report to the court. This progress report is a document that just says whether I meet the criteria. So whether I have had new arrest, whether my probation's been revoked in the past 24 months, and whether I've paid all restitution if I had any. And every year after that 3-year mark, my probation officer is supposed to submit a petition to terminate to the court to let the court know how I'm doing on probation, whether I'm meeting those criteria. And each year after that 3-year mark, my probation officer has the option to submit a petition to terminate my probation. So it's really important. What I tell folks to do is when they're talking to probation about early termination, if their probation officer is not willing to recommend them, and they're in that discretionary pathway, the all other offenses category, it's good to ask what they need to see from you to be willing to recommend you for early termination, because they have the option to do that every subsequent year. So let's talk about the process a little more. What happens if my probation officer submits a petition to terminate my probation? So the law that Rachel talked about at the beginning of this that was passed that streamlines this process, part of it included time limitations, so that when a petition is submitted, it's not just going to sit there for some random amount of time, and then maybe just it could be months, years. There's time limits built into this law. So when probation submits a petition to terminate, they will submit it again to the court and prosecutor. Within 30 days, the court can either grant the petition. They're supposed to grant the petition within 30 days unless the court or the prosecutor requests a hearing, an early termination hearing. If the court or prosecutor requests a hearing, that hearing has to be held within 90 days from the date that my probation officer submitted the petition. So the standard in the law is that the court will grant the petition if it determines it's in the best interest of justice and welfare of society to terminate my probation. I know that can sound a little gray, and candidly, it means different things depending on the judge. But in general, what we've seen is the court wants to know, what have I been doing since I've been on probation? What are the good things that I've accomplished? You know, maybe I have graduated from a program, maybe I've gotten a technical skill, maybe a new job, things like that, which I want to acknowledge I know are very difficult to do on probation. So acknowledging the accomplishments I've had. Have I been, the biggest thing I would say is, have I complied with and completed my special conditions? And even talking about, just anything like character references, things like that. And we talk more about that on our website and have slides about kind of what are some helpful things to show the court at a hearing. But that's the court standard they're looking at. And it's ultimately up to the judge whether or not to terminate a person's probation. So if my probation officer recommends me a petition submitted, the court ultimately has the decision on whether or not to terminate my probation. One thing I will say is, if someone's probation officer does submit a petition for them, it's really important to make sure that your address is updated with the court. So maybe I was sentenced in Fulton County, but now I live in DeKalb. It's really important that my address is updated with Fulton, because if an early termination hearing is requested, I want to make sure I get notice of that hearing, and it's important for my address to be updated. So you can update your address by contacting the clerk of court in the county where you were sentenced. So I mentioned there might be folks listening in who don't meet the criteria and might feel a little discouraged, or maybe their probation officer is just not willing to recommend them and they're on that discretionary pathway. A person can always file a motion for early termination of their probation. You can hire an attorney, or you can represent yourself. Our advice is always to hire an attorney if possible. And this law sets out timelines as well for folks who don't meet the criteria but file a motion on their own to terminate their probation. A hearing has to be scheduled within 90 days of the court receiving that motion for termination of probation. And similar to the standard I just read before, the court will grant the motion if it determines that essentially probation is no longer needed. It's in the best interest of justice and welfare of society and the rehabilitation of the defendant. Really, this language means similar to what I just said before, is the court wants to know what positive things has this person accomplished since being on probation? Have they completed their special conditions, things like that. So our website goes into a lot more detail and has resources about kind of the nitty-gritty on this process, but we wanted to provide a general overview. Now I'm going to pass it over back to Rachel Holmes to talk about just some best practices while on felony probation.
Thanks, Elizabeth. And before we get started, I did want to clarify something I said earlier about that every person is eligible and there are no any charges or anything that is carve-outs or exceptions. That is true. We've got several questions in the chat about what that means specifically for people that if you have a sexual offense that's charged and you're on the registry. That does not keep somebody from being eligible from early termination. But that does a lot of times put you in that discretionary path, which enables a probation officer to still request, but they might be saying that they're not going to use discretion to not request early termination at that time. And then that puts you in the category of what Elizabeth just discussed, of whether or not you want to request it on your own. I did also want to mention, though, that if you are running into issues with probation, with Department of Community Supervision and experiencing any issues with that, they do have an email address. And I will ask somebody to put in the chat in just a moment, but it is for people that are requesting issues that say because either they feel like they're getting incorrect information from their probation officer or feel that they're eligible but not being considered or have not been considered for any reasons. And it's early.termination@dcs.ga.gov. We'll put that in the chat, but that's another resource through probation that you can reach out to say, hey, I think I'm eligible and I'm not being considered, and I want to understand more of why I'm not being considered if you are not getting the information that you need from your probation officer. So just wanted to provide a little bit more clarity on that. But I am here today to talk about some more best practices while you're on probation. I'm also going to be joined by Dominique Harris, who is our Outreach and Reentry Associate. So if you see him pop up on the screen. So what can I do if I can't get in contact with my probation officer? So this is while you're on probation at any moment in time, or even if while you're trying to start the early termination process and are unable to. The first place to start is to contact the office in the county where you're serving probation. So DCES has a field office locator on their website. You can go on there, click, and it will give you a name, a phone number for the location of where you should be reporting. So that's wherever you're serving the probation, where you're living at this time. If you haven't had your probation transferred, then where you were previously at. And this will enable you to have a contact, and you would be contacting, and the first line of person that you would contact is called a duty probation officer. This person that's going to answer that phone and might be able to assist you. If you're not able to contact somebody via phone, then we always say that you can go to the office directly and try to contact that and try to connect with somebody there. The other thing is DCS has a call center, and the phone number is up on the screen. So if you're unsure of where you need to go, if you've been on call-in and you don't have your PIN anymore, or there's concerns of what you need to do, you can always call that DCS call center, and they'll be able to correct you directly to where you need to go and who to contact at that time. It's a great resource, and they can also help you start the early termination process as well. If you don't know where to start, if you contact that, they will put you in the right direction and where to move forward from that. So the next thing is how do I get on non-report? So Robin talked a little bit about non-report, and we really see that as a way that is one of the first steps to getting towards off of probation. It's not necessary, but it is a step that most people will move towards as you're getting off of early termination of probation. So everyone starts on active probation. So that means that you are reporting to probation. Most people on probation will go on non-report after 2 years. Sometimes that can be earlier, could be said on your disposition or your sentence if there is a chance for you to get off of probation earlier, or get off of non-report earlier. Non-report means that you're reporting less, but does not mean that any of your conditions of probation go away. So this means that you might be on call-in at the beginning, but then you'll eventually, for non-report, will get off where you would have to call every month. But what will mean is that you're still on probation. So all the conditions of your probation remain. So that means if you still had any special conditions that had not been completed, stay away orders or restitution, those still exist, and you still must abide by all of those conditions. We also say while you're on non-report to please keep up your address and phone number up the same. So that way they can get in contact with you if they ever need to, especially if they're looking at starting on the early termination process. They're going to need to be able to contact you to start that. A lot of times between non-report or between active probation and non-report is when you get on that monthly call-in, and then you'll be able to go to non-report. If you've been on probation for 2 years and you have not been moved to non-report, then you can absolutely ask your probation officer to move you to non-report. And they can talk to you about with the possibility of that. So that way you have less check-ins with probation. One thing to be aware though is that you can still be revoked while you're on non-report. Your probation can still be revoked, which is why it's so important for us to be able to get off of probation altogether correctly. So next is how are you communicating with your probation officer? So this begins at the very beginning of your probation. And what we say is that you are your best advocate while you're on probation. And for those purposes, we say to keep copies of every proof of completion that you've had for any of your classes, community service, or anything that you're giving to probation. Do not give them the only copy. You need to remain to have a copy of yourself. One, for you to know that you've completed on probation, and two, for yourself to be able to provide to probation to the court later on if necessary. If your probation officer changes, you might need to produce those documents again. Hopefully they have them, but if not, you want to be able to produce them. We also say to keep a record of all communication that you have with your probation officer. So for my clients, I always have them set up an email address that's solely for all communications with probation. Make sure that they have that information. Make sure that they either email themselves all the information that they need, whether that is their PIN numbers to check in, their probation officer's contact information, their email. So that way, even if they lose their phone, they still have an email that has all that information. And then when you're doing that, if you have phone calls with your probation officer, you can screenshot and email it to yourself so you can keep it. So it's a good way for you to be able to say, these are the times that I contacted probation. These are the way I communicate with my previous probation officer. And that way, if it ever comes up in the court, you have this for your attorney or for yourself to present to the court. The same thing when any documents that you request to your probation officer, keep those. So if your probation officer gives you something that says that you're now on non-report, that's a good document to keep so you have that. Any travel permits, transfers, all that stuff, we'd also say to keep. And also don't wait for last minute to ask. So for travel permits, we always advise to ask as soon as you know that you're traveling. So that way you have time, probation has time to process it. Transfers, what we're talking about is really transferring your probation from one jurisdiction to another. It's always best to be on the front end of that and to ask probation beforehand and tell them your change of address before you're moving. There is a forward-facing portal in many jurisdictions right now. So what I would also advise is if you're talking to your probation officer, ask if there's a forward-facing portal. This forward-facing portal allows you to request transfers, travel permits, hardship exemptions, community service waivers, and all that stuff through the actual forward-facing portal, which will give you better access to be able to request that, and also for you to be able to keep all the information that you have in one location as well. So keeping up with your probation officer at the very beginning, I also say to do that at the very beginning a lot. Talk to them a lot so they know that you're going to be communicative. They know that you're on top of it, and that can be a better relationship as you continue on in probation. I know it can be difficult to get in contact with probation officers, which is why we have that previous slide and say that you're yourself best advocate to keep all that information yourself as well. So next is being diligent with your conditions. Talk to your probation officer about any conditions you do not understand. Unfortunately, probation sentences come with sometimes usually around 15 to 18 different general conditions of probation. There are a lot, and a lot of them have nothing to do specifically with your situation or a case, but are just general conditions that everybody has. And what those are, sometimes they're avoiding injurious and vicious habits, avoiding persons and places susceptible of harmful character. What does that mean? That's why you need to talk to your probation officer. It can mean different things to different probation officers. Very rarely do you ever have those things that come up, but I think it's best if you're concerned for you to talk to your probation officer, ask him if that's something that's going to be a problem with where you're working, where you're living, and go ahead and ask that so you know, and you have in writing and have talked to them about whether or not this is going to be in violation of your probation. When you're completing your conditions and community service, those kind of things can be helpful to get you to non-report sooner, and are also going to be things that they're going to be looking at when they are talking to you about whether or not they will submit a petition for early termination. So these types of conditions are things that can be, as you're working through them, can be helpful for probation to ask for early termination of probation, and stuff that the judge will be looking at when you get to a hearing for early termination of probation. So we say be diligent with your conditions and know your conditions. It's really important to look at your disposition and see all the different conditions. Like Elizabeth talked about, you could have general conditions, but also those special conditions to know exactly specifically what they are and what time frames you have to complete those conditions. So next, I'm going to pass it off to Dominique Harris to finish this off.
Hey everybody, thank you, Rachel. Thank you, Rachel. And I didn't jump in because I'm just gonna reiterate 2 points before I finish this off. I see people stumble a lot with fines and fees. So one thing just to remember even if you owe fines and fees, still report. And also people being on non-report, just because you're on non-report does not mean that you can't get violated. So if you're on non-report, that is more of a reason to pursue early termination because you've been doing good. So what should you do if you think you qualify? The first thing you should do is call your probation officer. I know a lot of times people don't know their probation officer. So you can call the county's probation officer. So if you have a case in the cab, that'll be the cab. Or if a case enforcement, that'll be Fulton. Lastly, I know I think we mentioned this number earlier, but this is the DCS call center, and you can call that number. Tell your probation officer that you think you qualify for early termination, and just ask them, have they been submitting progress reports, and do they recommend that your probation get terminated? You can visit our website for more things to say, because this can be a nuanced conversation, whether they say they don't recommend you, but you feel you qualify, or that you feel you don't qualify and you need to know what you can do as far as pursuing early termination in another way. At the bottom is the DCS email that you can reach out to them to get any information and start the process. Now, who can vote, right? First of all, why should you vote? I tell everyone you should vote because the lawmakers are the ones that make the laws. And this bill is an example of why you should vote. This bill was passed in 2021 and over 20,000 people have got their probation terminated. So we should vote because the people that are in office are in there for our best interest. So who can vote in Georgia? Anybody basically not serving a sentence. And your voting rights are established. I'm sorry, not established, but restored after your sentence is complete. What that means is the whole sentence. That's incarceration and probation. That means off paper and done with incarceration. All you have to do once your sentence is over with is re-register. Anyone that's serving a first offender sentence, under the First Offender Act or unconditional discharge can vote, because that's technically not a conviction. And as far as the Secretary of State website, fines and fees does not stop an individual from voting. That is at the bottom. All unpaid monetary obligations do not keep an individual voting as long as your sentence is complete. So that underlying word or underlying phrase, sentence complete, that's incarceration and probation. And now this is a little bit about PubMed, the material that we send out, and we send it out for free. But if anyone can, to keep it going, it's for a small donation. But these first posters is the Pathways of Probation campaign that we alluded to a little earlier, and we send these out. The middle poster, the front side, the back side is probation and all the information that we gave just in a nutshell, and the other side is voting information. More is how to follow us on social media and just get in contact with us and help us spread this word and bring awareness in the community. Just reach out. Thank everyone for attending. Like Rachel said, I'm Dominique Harris, the Outreach and Reentry Associate, and I just thank everyone for attending.
Thank you, Dominique. I think we want to put one more thing in the chat, which is the website that has all the information about early termination of probation on it. So I will put it there, and it also has our contact information like it has on the screen. Thank you.